In this pandemic, our frontliners are putting their lives at risk. Some may not be prepared for what's to come, but what if something happens to them, like with Mario's wife? It is worth knowing whether or not you need a will. This actually concerns everyone, not just the frontliners. So let me just quickly show you. I made this will. This is my will, which I prepared quite a while back. It is a legal document. Okay. Your will lets you decide what happens to your money, property, possessions, and even your children after your death. If you make a will, you can also make sure you don't pay more inheritance tax than you need to. You can write your will yourself, like I did, but you should get advice if your will isn't straightforward. You need to get your will formally witnessed and signed to make it legally valid. If you want to update your will, you need to make an official alteration, what is called a codicil, or just make a new will. If you die without a valid will, it could be difficult for your family to sort out your affairs. Your estate will be shared out according to the rules of intestacy. Under these rules, only married partners, civil partners, and certain close relatives can inherit your estate. If you and your partner are not married or in a civil partnership, your partner won't have the right to inherit. So basically, if you're just living together and not married or in civil partnership, you won't get anything. If no will, what the partner and children can get. If there are surviving children, grandchildren, or great grandchildren of the person who died, and their estate is valued at more than £270,000, the partner will inherit. I think we'll have to change the slide there, Chad. So basically, what you'll get, all the personal property and belongings of the person who has died, and the first £270,000 of the estate, and then half of the remaining estate. So the spouse will get a big chunk of the estate of the deceased. If there are no surviving children, grandchildren, or great-grandchildren, the partner will inherit all the personal property and belongings of the person who has died and the whole of the estate with interest from the date of death. Now, what about the property you have bought together as a couple and if you have a bank account? So this basically would apply to Mario. Now, there are two different ways of jointly owning a home. These are beneficial joint tenancies and tenancies in common. So that's the slide showing now. And how do you know if you own the property as joint tenants and tenancy in common? Basically, when you bought the property, there would be a form that you need to sign, and there's a question how you wish to hold the property. And that would be reflected on the official register, your land registry title. This is now on public record. If you can't remember how you held the property, you can actually go online and check the land registry website. You pay £3 to print out there and then your title to the property. So I have mine, and that it looks like this. Okay, and then there's 3 registers, and if you look on the register about who owns the property that's registered, and this is actually on this bit here, you will see if there's no restriction on your title, that means you hold the property as joint tenants. Now, if the partners were beneficial joint tenants at the time of the death, when the first partner dies, the surviving partner will automatically inherit the other partner's share of the property. It is not necessary to have a will. It will not form part of the estate of the deceased partner. Now, however, if the partners are tenants in common, the surviving partner does not automatically inherit the other person's share. In this case, it is necessary to have a will to state who will inherit the deceased partner's share. Now, you have to really make sure that you check how you own the property. If it's tenancy in common, then your share, if the deceased partner's share, it will go to the whoever is the next of kin, and that will be set out in your will. Now, going now to joint bank account or building society accounts. If one dies, the other partner will automatically inherit the whole of the money. Now, as I said earlier, property and money that the surviving partner inherits does not count as part of the estate of the person who has died when it is being valued for the intestacy rules. What about other close relatives? Now, parents, brothers, sisters, and nieces and nephews of the intestate person may inherit under the rules of intestacy. Now, this will depend on a number of circumstances, whether there is a surviving married or civil partner, whether there are children, grandchildren, or great grandchildren. In the case of nephews and nieces, whether the parent directly related to the person who has died is also dead, and the amount of the estate. Now, we'll have to look at the order of priorities. So, who will get the share? You will have firstly the grandparents, then uncles and aunts, a cousin who can inherit instead if the uncle or aunt who would have inherited died before the intestate person.
Mm-hmm.
You have the half uncles and half aunts. A half cousin can inherit as well. Now, what you need to watch out for when you're making a will. Now, make sure it's valid. Your will is only valid if two witnesses watch you sign it. Okay, you cannot sign it before. You have to sign it in front of your two witnesses. So again, looking at my will, right at the end, you have your signature there. I don't know if you can see it. And then you have the two witnesses. I've actually put there. So my signature and then the signature of the witnesses. They must sign the will, but do not need to read it. So your witnesses must be over 18, not be your beneficiaries. They will not benefit in the estate. Not be your beneficiary spouses or civil partners. And you must keep it safe. Now, make sure your executors know where your will is kept. They must have access to it without needing to apply for legal permission. Do not store your will in a bank safety deposit box. The bank will not be able to open it until the executor gets legal permission, which won't be granted without your will. Now, you can leave your will with a solicitor. They'll give you a copy. There's no charge for this service if you leave it with a solicitor who drew up your will. Now, you can store it with the government's probate service as well. Now, it is important that you use a solicitor when you share a property with someone who is not your wife, husband, or civil partner. You also have a dependent, such as a child who cannot care for themselves, and you have several family members who may make a claim on the will. If you own a property overseas or a business, and your permanent home is not in the UK. Now, going back to about the £60,000 compensation if a frontliner dies, and it will be given to the family members. So it will go firstly to the surviving spouse first. And if there's no spouse, then the children or grandchildren or great-grandchildren. And if none of the above, then other relatives. Okay. Now, who cannot inherit? So, who you have the unmarried partners, they cannot inherit from the estate. Same-sex partners who are and not in a civil partnership, relations by marriage, close friends, and carers. So, unfortunately, they cannot inherit. Now, if there are no surviving relatives, the estate passes to the crown, to the queen. It's called bona vacancia. Now, executors, very important. These are people named in your will who will carry out your wishes after you die. They can be family or friends, but you should ask them first if they're willing to take on this role, as it involves a lot of responsibility. An executor can also be a professional person, such as your solicitor. If you use a solicitor for this service, you'll have to pay a fee. Now, most people have 2 executors, but you can have up to 4. You should at least have a second executor in case your main one is unable to act on your behalf. Now, what if, as I said earlier, you have a property in the Philippines and you have a property in the UK? You can have an executor in the Philippines and you can have also an executor in the UK under the same will. Or you can have 2 wills, one in the Philippines or your home country and one in the UK. So that will be enforceable in its respective countries. And I think that's it for me. I'm sorry this slide is a little bit off, but I hope you're able to follow.
Mario, meron po ba, Boyet, meron ka bang katanungan sa ating solicitor related to your experience or maybe what you need right now?
Actually, ngayon, wala pa naman, wala naman ako, kasi, yung anak ko kasi 14 years old and, siguro, yun na lang ang anuhin ko na, kasi, ko sa kanya para sa university niya.
Mm-hmm. See, it's very difficult what you're going through this time, and I do empathize with you. You have a lot on your plate. You have to deal with what's going on around you. You have to deal with the paperwork. You mentioned about the mortgage, and I'm sure you probably have contacted your mortgage lender. They will be very sympathetic. If you own the property jointly, is that the case? You obviously, if your name is on the title, you would be on the mortgage as well. So you would need to speak to your mortgage lender in order to transfer the name into your sole name. So if it's in joint names, it would be transferred in your sole name. But you really have to speak to your mortgage lender to find out what would be the requirements. But normally, you would need to produce the death certificate.
Yeah. Always. Kasi every time kailangan talaga yung death certificate at saka talaga yung pag ka sa kanila, yung hinahanap nila puro original. Mm-hmm. Kaya lang medyo delay lang lagi kasi every time i-post mo, matagal ang balik.
Okay, so actually maganda yung mga sinabi ni Crystal, no? Sa kaso mo, Boyet, okay lang kasi at least nandito ka bilang pamilya ni Amor. And ang question is, kung ang isang frontliner na namatay ay mag-isa lang dito sa UK. So, anong dapat niyang gawin? So, normally, yung will dapat may executor, no, para may magmamanage ng mga affairs nung namatay. Pwede namang ipangalan sa isang kaibigan para kung may mangyari, o dalawang kaibigan, para kung may mangyari, meron agad kikilos at may magagawa sila para maklaim kung ano may mga dapat i-claim. Yun ba, yung 60,000 o kung may property siya dito, may bank accounts. So, in your case naman, I can see na mukhang kailangan mo yata magkaroon ka ng will kasi 3 yung anak mo para at least malinaw ang usapan ika nga. Kasi kung siyempre may bahay kayo dito, baka may properties din kayo sa Pilipinas, at least nakalista lahat kung anong mangyayari kung dumating ang araw.
Yeah, just planning that kasi mahirap talaga pag hindi mo i-secure in case mahirapan din yung pamilya mo paano nila i-process. Kaya ngayon may lesson na talaga ako na ganong sitwasyon.
Okay.
Kaya every time mo na sa sure talaga na hindi mahirapan yung pamilya mo in case.
See, Jane is actually absolutely right there. If you have a child who's under 18 and you are sole parent now, you do need to have a will, because in your will you can include in there who's going to be the guardian of your child. So it's really important that you trust that person and that they agree, first of all, to be the guardian of that child, and then you can put the name in the will.
Okay. Mario, maraming salamat sa ibinahagi mo sa amin. But maybe before we wrap up, bago natin tapusin yung segment na ito, ano yung gusto mong alaalang maiwan ng asawa mo na si Amor, na dahil sa COVID-19, her life was cut short?
Ang masasabi ko lang, lalo na sa iba, ang kay Mrs. kasi dami kaming yung mga before pa na pinagsamahan, every time na mag-holiday kami, every time na mahirap talaga yung sitwasyon kasi mo lahat ma-remember mo lahat kung anong pinagsamahan nyo, kung saan kayo nag-holiday, lagi kayo magkasama. Na kami 27 years na nagsama. Kaya medyo mahirap talaga yung sa isip. Ay, yung mga bata lang ko na kasi may 14 years old ako, yung inanuhan ko rin kasi. Parang hindi niyo pa masyado cope up kung anong sitwasyon niyo.
Nasaan po yung anak niyo ngayon?
Actually, nandun siya sa kapatid niya kasi dito. Hindi siya makapaglabas-labas, natakot din siya, kaya sabi ko sige mag-ano ka muna doon kasi countryside para at least makapaglakad-lakad ka kasi mas maganda, hindi masyado marami tao doon. At saka maiba naman yung environment niya kasi dito lang sa bahay parang maalala niya rin lagi yung mga sitwasyon. Pero hindi naman siya naman siya, babalik naman siya next week.
Okay. Well,
can I just mention one more thing,
yeah.
Rose? Okay, so if anyone who would like a will, you can, as I said earlier, you can write it yourself, but there's also companies, will writers, to do it for you, or a solicitor, they're regulated by the SRA, or if you're intending to give part of your estate to a charity. Now, a lot of charities doing wills, they're drafting wills for free. So perhaps in your case, if you don't have any family members to leave your estate, then you can leave them to a charity. But the charities, they do have a approved solicitors who can draft the will for you. So that's it.
Okay. Maraming salamat. Thank you for the thorough discussion, for briefing us, Crystal, and also kay Mario or Boyet for sharing your story with us. Maraming salamat po. Again, nakikiramay po kami sa pagkawala ng inyong asawa. Gusto naming maalala si Amor Gatinaw bilang isang magiting na nurse na nagserbisyo po sa National Health Service at itinaas ang bandila ng Pinoy dito sa United Kingdom. Sa panahon ng pandemic ay nagserbisyo po siya at nagtrabaho para po makatulong sa National Health Service. So, mabuhay si Amor Gatinaw at ang kanyang pamilya. Sana ay ipagdadasal po namin kayo sa in this difficult situation. Thank you so much.